right, we got another question that's come up a lot is search instant to a non-custodial arrest, like a summons, for a crime where evidence could reasonably be located on a person legal? All right, so my name is Anthony Bandiero, bringing to the Roadside Chat. This cop is in Colorado. He says, I watched episode 421, which is search instant to a summons and so forth, right? I understand why a search instant to a trespass summons would not fly. Right, because you're not going to find evidence of a trespass on the person. You just issue them a citation and be gone with you. But if I'm issuing a summons for a misdemeanor meth possession, could I reasonably use People versus Bland as a justification to look for additional evidence of that specific crime on the person? What a great question, and actually, what a great case. People versus Bland is a case from 1994 from the great state of Colorado. What happened there in a nutshell is in 1994, possessing less than an ounce of marijuana was a mandatory summons. Okay, you cannot arrest back in this day. Right now, the rules are even more different because in Colorado today, under a certain amount of I forget whether it's under an ounce or whatever, it's close to that, but that is decriminalized. Okay, but back in 1994, it was actually still illegal to possess marijuana, but the legislature held that it cannot be you cannot arrest a person for it. So Bland was stopped for reasonably believed to possess less than an ounce, but he was still searched for more evidence, and they found more evidence, and he was ultimately arrested. So the case is from 1994. I'll put the citation in the description below. But the court held, and I quote, right, it said that, therefore, in the context of a non-custodial arrest, the arresting officer is entitled only to conduct a pat-down, search for weapons in circumstances where such a search would be authorized under the Terry list of cases, right? That makes sense. We can always do a Terry pat-down if we have reasons to believe that the person could be armed or dangerous. But they also went on, and a search for instrumentalities or evidence of a specific crime for which the officer had probable cause to make the arrest. Usually in the case of non-custodial arrests for traffic violations, at most, only a pat-down search will be indicated, right? Authorized. Since a search of the person generally will not reveal any kind of evidence of the crime. But they went on to say non-custodial arrest for possession of 1 ounce or less of marijuana in violation of subsection 18-18-406, which I'm sure has been, repealed by now, right? In contrast, may permit not only the weapons frisk, but also an extensive search for evidence of marijuana possession. Now, my suggestion for these cases is that when you do these type of evidence-related searches, you articulate a few things. Number one, you have probable cause that they have more evidence on them. That's what I believe the courts are looking for, at least ultimately at the Supreme Court, right? In other words, if we are going to issue a citation for somebody for some kind of, paraphernalia and so forth, and we start searching them, and the court asks us, hey, why are you searching that person when you're going to, cite them for the meth pipe? And you say, well, because they had a meth pipe. I'm not sure that's going to be enough. I know the courts, are going to want to know, why do you think the person has evidence on them right now? Go on. They will also want reason to believe there's exigency. The fact that the people know that they may have evidence on them, creates kind of exigency because you're going to release them. But I think most importantly, not only do you have the PC, they have evidence on them, or articulate why, but also the search is limited. Now, Bland kind of insinuates that you can do a full search instant to arrest, even if you're not going to arrest them. I don't think the courts would have an appetite for that. Why are you searching their wallet and, every little crevice of their wallet and, in their shoes and their belt line and so forth? I think the courts would want something a little more circumscribed, at least looking in areas where the evidence could be. I'll give you a great example, right? So when it comes to, methamphetamine, and it's a non-custodial arrest, that's a pretty comprehensive search, where those drugs could be, right? But let's say that you have a non-custodial citation or situation for shoplifting, and you have probable cause to believe that they stole a candy bar. I don't believe that you can look in the Altoids can unless that candy bar is so small that you believe it could fit in there, right? But if you were looking for the narcotics, I do believe you can probably look in the Altoids can, right? That's a common place that people can put drugs and so forth. It's a great question. Again, I'll put the citation in the description below. Keep the questions coming. If you like what we're doing here, do me a favor. Like, subscribe, share with your friends. And until next time, my friends, you stay safe.